The ACT has decriminalised abortion, and there's good access to services there, and so has the Northern Territory. It's now in the Medical Services Act there, and they have the same grounds as South Australia. There's good access in towns, but less so, obviously, for rural and remote women. Victoria is a beacon for us all. Abortion was decriminalised here in 2008, and the Premier himself led the process to the Victorian Law Reform Commission, saying that existing laws were out of step with community feeling. Decriminalised to 24 weeks of pregnancy, with it being possible to perform an abortion after that if two doctors agreed that it was appropriate. It is appropriate. It must be performed by a registered medical practitioner. Doctors with conscientious objections to abortion do not have to be involved in the counselling or the performance of the abortion, but they must make an effective referral, which doesn't mean they have to refer to someone who's going to provide the abortion, but they must refer to an organisation such as Family Planning Victoria, who will objectively discuss all the options with the woman. And this has meant that there is good access to abortion, certainly in urban areas in Victoria. It is still harder in some rural areas. Now, I just want to speak briefly about the Manhattan ruling, because it still affects us. It no longer has a place, obviously, in practice in Victoria, but it does in Queensland. This dates back to 1969, when Justice Manhattan ruled in the case of Dr. Davidson, who was acquitted of procuring an abortion, that the abortion would be unlawful if the person performing it did not honestly believe that the abortion was necessary on the grounds of the woman's physical or mental health. And as I said, in 1972, Justice Levine ruled in a similar case the same way. This had the effect in Queensland of bringing a certain Dr. Bayliss to set up an abortion clinic in Brisbane. Dr. Bayliss died in the 1990s. I've never met him. He was described by the media at the time as being a colourful character. I think that if you were going to set up an abortion clinic in Bjelke-Petersen's Brisbane, you had to be a colourful character. Anyway, he set up his clinic. He was practiced for a number of years. And in 1985, his clinic was raided by a busload of police. There they are. They searched the drains fruitlessly, and they took away Dr. Bayliss, who actually looks quite calm, and he was charged under Section 224. And I won't go into the details of the case, but he was acquitted. He and his anaesthetist, Dr. Cullen, were acquitted. And the judgment was made by Justice McGuire. It was in the District Court, and he drew on the Manhattan case and on the Levine case, and he included both necessity, which had appeared in the Manhattan ruling, and proportion. That is, the abortion had been done to avoid otherwise inevitable consequences, and the dangers of the abortion itself must be in proportion to the dangers to be averted. So this is the case law on which Queensland doctors have since relied when performing abortions in that state. And there haven't been any further prosecutions of doctors since then. However, in September 2009, Tegan Leach and Sergi Brennan were committed to stand trial in Cairns District Court, charged with sections 225 and 226 of the Queensland Criminal Code. Now, how on earth did this extraordinary event come about? Their house had been searched by police in January 2009 on an unrelated matter, which never led to any prosecution of the couple. And the police found empty packets of tablets together with foreign writing. And the couple freely stated that the medication had been sent by Brennan's, he was of Ukrainian origin, sent by Brennan's sister. They did not attempt to smuggle this drug in. She put it in the post. There was a photo produced in court of the package. It had one of those green custom stickers which said exactly what it contained. And Sergi Brennan subsequently said, "I thought that if it was illegal, the customs would have taken it." It's a perfectly reasonable conclusion. So they told the police that the medication had been used for an early abortion. So the police dusted off their copies of the criminal code and they prosecuted them under the criminal law. And they pushed the case through the Magistrates Court to the District Court in October 2010. Now, the arguments by the defence, Mr Kevin McCreena, a Cairns barrister, were first of all that Section 282 was not relevant to Tegan Leach because she had no life-threatening or otherwise serious medical condition that would justify an abortion. And his argument therefore rested on the wording of Section 225. She freely admitted that she'd used the combination of mifepristone, 8486 and misoprostol. McCreena looked at whether this was a poison, a noxious thing, a force, or any other means whatsoever. And medical evidence was called, and Professor Nick Fisk of the University of Queensland was asked about the noxiousness of mifepristone and misoprostol. He pointed out that these drugs were widely used overseas and even to some extent in Australia for medical abortion, and in his opinion, the drug combination was not a poison nor a noxious thing. The jury consisted of 12 Cairns citizens. I sat through the whole case and they seemed to me to be very typical of the population of Cairns, 8 women, 4 men. They listened very hard. They asked the judge a number of questions and he complimented them as being up to speed. And they listened to evidence for 2 days. They took 40 minutes to deliberate and there was a unanimous verdict of not guilty and there was much applause from the public gallery. So what are the implications of the result now for Queensland? Well, we have argued very strongly that since, as you've seen, the wording of sections 225 and 226 are very similar, if Tegan Leach was not committing a crime using mifepristone and misoprostol, then we are not either. It is not a noxious thing. We are not committing a crime. We do not have to worry about section 282. Now, this has led to a fair amount of discussion in Queensland legal circles. Because this is a district court, this was a district court case, it's a fairly low-level court. There were perhaps some questions about the judge's directions to the jury. I think it would be true to say that he was reasonably sympathetic to the defendants. Decisions by juries are not, they don't act as precedents the way those do in higher courts. You'll understand that better than I do, but I understand the principle. But on the plus side, the government has not appealed the judge's directions, so the case rests. And it seems to me to have the same kind of precedent value as the Bayliss case, which was also heard in the district court and was not appealed, and which has quite often been cited by the Queensland Attorney-General as being a protection to doctors in Queensland when they're asked to actually change the law. One other implication of the case is that there was no prosecution for importing the drugs, which is what the police could have chosen to do. They used the criminal law, and the couple were found not guilty. So that other people importing or otherwise obtaining mifepristone and misoprostol, if they were prosecuted, could presumably point to the verdict and say, well, it's not illegal for me to use these for abortion. And certainly if medical abortion continues to be restricted in Australia and particularly in Queensland, it is becoming widely known that mifepristone can be bought on the net, and this is likely to increase. And this is unsatisfactory. People should not be having to clandestinely perform abortions for themselves. They should have access to these services. So what do we want in Queensland? While we think that we can use this case positively, we are still in a grey area practicing abortion in Queensland. We want decriminalisation. We want sections 224 to 226 and 282 completely removed from the criminal code. And we want abortion regulated in the Health Acts of Queensland. Obviously, abortion should only be performed or under the supervision of registered medical practitioners, but we think that the woman should never, ever be charged. What do we want across Australia? We need uniform abortion laws. There needs to be an agreement between state and Commonwealth health ministers to bring abortion law across Australia into the 21st century. Abortion is a very important health issue for Australian women. We don't count abortions in Australia because if we don't count them, then perhaps we don't really have them. But we do know that there are probably about 100,000 annually. 1 in 3 Australian women will have an abortion sometime during her reproductive life. Now, like everybody, I think, in the pro-choice movement, I don't view this figure with equanimity. I would like to see our abortion rate fall. Our abortion rate is 3 to 4 times higher than that of countries like Belgium and Holland and Scandinavia, which actually have much better sex education in schools, much better contraceptive services linked into the main health system, and much better contraceptive information. And that is the way to lower the abortion rate. Our Premier has not been helpful in the matter, but she has said very frequently to the media, abortion is a matter for a woman and her doctor. Unfortunately, that's not the case in Queensland. Abortion is a matter for a woman and her doctor and her lawyer. We would like to exclude the lawyer. And in doing that, we feel there should never, ever be another case like that of Tegan Leach and Sergey Brennan. Never, ever again. Thank you.
Thank you, Caroline. I think that you'd all agree with me that you had absolutely no reason to be apprehensive about speaking to a bunch of lawyers, because I don't think many people would have such a broad and deep understanding of abortion law as that. So thank you very much. Now, I'm sure that people will have questions for Caroline, especially about the Tegan Leach case, but I'd ask you to please hold those questions until the end, and also for the continued discussion space.